Hi everyone, and welcome back to Elise Explains IP, the podcast where we make intellectual property make sense. Today we're talking about international trademarks, when you actually need them, and when you might be taking a bigger risk than you realise by not having them. Because here's the truth, trademarks are territorial. There's no such thing as a worldwide trademark registration. Let's unpack what that means a little bit in practice. Firstly, as I said, trademarks are territorial. Always. When you register a trademark in Australia through IP Australia, you get protection in Australia. That's it. It does not give you any rights in China, in the United States, in Europe, or anywhere else. Every country or region has its own trademark system. So the first question is never, should I file internationally? The question is, where am I using or planning to use this brand? If you manufacture in China, Vietnam, India, or elsewhere in Asia, you may need trademark protection there, even if you don't sell into those markets. Why? Because jurisdictions like China operate on a strict first-to-file basis. Whoever files first generally wins. That creates a very specific risk that your distributor, your factory, or a third-party trademark squatter can register your brand before you do. And then they can block exports, seize your goods at customs, and demand payment for them to transfer the registration to you. This is not a theoretical risk. For example, luxury brand Jimmy Choo was involved in a long-running trademark dispute in China. A local party had registered the Chinese transliteration of the Jimmy Choo brand before the company had secured its own protection. That registration created years of litigation and commercial limitation. Jimmy Choo just couldn't be in China. The issue wasn't that Jimmy Choo was not globally famous. It was that fame elsewhere did not automatically translate into ownership in China. China's system rewards early filing, not reputation alone. The takeaway for people and brand watchers is that even globally recognised brands can lose control of their own name if they delay filing in first-to-file jurisdictions. Similarly, Australian wine icon Penfolds has faced repeated trademark and branding disputes in China. Various local entities have registered similar Chinese character marks, confusingly similar branding, and parallel labels. China is a crucial export market for premium Australian wine, so this is a huge problem for them. When a third party registers a similar mark, it can divert sales, cause consumer confusion, require lengthy invalidation proceedings, and costly enforcement action. And importantly, even if you do ultimately succeed, you spend years and significant legal costs defending what you assumed was already yours. This is what happens when a filing strategy lags behind commercial reality. Now, let's flip the scenario. You've been trading in Australia for 5 years. You expand into the US, no problems, right? Except someone registered your brand there 3 years ago. You cannot rely on your Australian registration. You are the infringer in that scenario. They can block your marketplace listings on Amazon or eBay, issue cease and desist letters, record their mark with customs, and demand licensing fees. Trademark rights are a proprietary right. Ownership is jurisdiction specific. Before entering a new market, clearance searches are not optional. They are risk mitigation. Even for the small guys. You start up a very small e-commerce business selling doodads to anyone who stops by your Shopify storefront. This is the modern danger zone. If you have global shipping and US dollar pricing, you are suddenly using your trademark internationally. Anywhere that you make a sale could be one of your geographic areas. If your site targets customers in another country, you may be infringing someone else's registered mark there. E-commerce removes geographic limitations, but trademark law does not. I see founders assume, I'm based in Australia, so I'm protected. That assumption is wrong. A brand that is perfectly safe in Australia can infringe overseas the moment your storefront goes live globally. So if you are building a scalable online business, international trademark strategy should be part of your launch planning, not an afterthought. Now let's talk about how you can file internationally. There are two main pathways Australian businesses can use. The first option is a convention application. Under the Paris Convention system, you can file your trademark in Australia first, and then file in other countries within 6 months, and claim your Australian filing date as your priority date. This is called a convention application. It means that each country application is separate, and you have to instruct a local attorney in each jurisdiction. All of the applications are independent. Some advantages are that there's no dependency on your Australian trademark, there's more flexibility, and there's often better risk for jurisdictions like the US or China. The obvious disadvantages are more administration and more costs up front. The second option is filing through the Madrid system. This is filing through the World Intellectual Property Organization under the Madrid Protocol. This allows you to file one international application, and then you nominate the member countries that you would like to designate your trademark into, and it manages your renewals centrally. It's streamlined and often more cost-effective. However, and this is critical, for the first 5 years, your international registration depends on your Australian base application or registration. So if your Australian trademark is opposed, or limited, or even cancelled, your entire Madrid registration can collapse. This is what's called a central attack. The Madrid system is efficient, but it carries that structural risk. So the decision between a convention filing and a Madrid filing depends on your budget, risk tolerance, expansion strategy, and the strength of your Australian application. If you want to choose a strong trademark in Australia, check out my most recent podcast. There's no universal right answer. So, when do you need a trademark internationally? You're likely to need them if you manufacture overseas, if you plan to expand in the next 12 months, if you operate unrestricted e-commerce, if you are pitching to investors who will ask you about global brand protection, and if your brand is core to your enterprise and value. You may not need them immediately if you are purely local, for example, a local service, if you've got no overseas suppliers and you have no expansion plans. But the moment international expansion comes into the picture, trademarks become strategic, not just defensive. If you delay filing in the first to file jurisdictions, like China, you may be forced into litigation, negotiation, a buyback scheme, or rebranding. And as Jimmy Choo and Penfolds illustrate, even major brands are not immune. International trademark protection is not about ego. It's about risk management, supply chain control, asset protection, and preserving scalability. Your brand is often your most valuable intangible asset. And once somebody else owns it in a key jurisdiction, unwinding that problem is expensive. Much more expensive than filing early. If you found this helpful, share it with a founder, e-commerce operator, or an advisor who needs to hear it. And as always, this is general information, not legal advice. Thanks for listening to Elise Explains IP, and I'll see you next time. Thanks for spending time with me on Elise Explains IP. If you picked up something useful, hit follow, subscribe, leave us a review, or send it to a founder friend who could use this information. And remember, this is general information, not legal advice. If you do want help with your IP, you can book a strategy call with me at any time via my website. The link's in the description. So until next time, own your own ideas.